Hello. Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Professor Patricia Kane. Patricia Kane is a professor of law at Santa Clara University. She's been teaching law for over 35 years. Couldn't be. Must have been somebody else. She briefly practiced law before she became a professor, and she's a member of the Texas and Iowa bars and provides consulting services to law firms. Patricia is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. Today, we're going to be talking about some new developments for income and estate planning for same-sex couples. Some months ago, Patricia and I did a couple of shows related to that. You can see those at our website, Financial Insider Weekly, under past episodes. Before we get started, a little caution. We're discussing some issues in a very complex area. I see this as a starting point for a bigger discussion with your tax advisor. We want you to get qualified legal and tax advice. And also, we're mostly addressing issues from federal and California standpoints because we're California people. So California is a community property state. That's a big part of what we're talking about today. Viewers in other states should seek advice from their advisors about their local laws. So with that, Patricia, let's get started and welcome.
Thank you so much, Michael. It's very nice to be back again.
Yes, thank you very much for being with me today. All right. Well, what has happened since we had our earlier interviews is, first of all, the IRS has had some new letter rulings. And one of them is actually a chief counsel advice.
Yeah, they've actually issued 2 chief counsel advisories and 1 private letter ruling.
Okay. So these relate to how California RDPs should report community income. And so maybe you could tell us a little bit about what they said.
Right. Well, to give a little historical context, you may recall that in January 1, 2005, California law changed for registered domestic partners. That's the first time that registered domestic partners were subjected to the community property regime. Now, many of us in the legal and tax community thought that that meant that for tax purposes at the federal level, that RDP should be splitting their community income 50-50, because that has been the rule since 1930, decided in a very famous case by the United States Supreme Court, Poe versus Seaborn, held that community income is really owned by the 2 spouses, or in this case it would be the 2 partners, and therefore should be split 50-50. Right. The IRS, however, disagreed, and so in 2006 they came out with a chief counsel advisory in that year that said registered domestic partners could not rely on Poe versus Seaborn to split their personal service income. Now they've changed their mind. Now they agree with those of us who thought that Poe versus Seaborn applied all along, although they make a point that California changed its own state tax law in 2007 to say that before that time, registered domestic partners reported as single at the state and the federal level. And in 2007, that state law was changed so that registered domestic partners filed jointly, and there was a statute that the legislature had enacted that said community earnings, personal service earnings, would be reported separately, and they changed that law in 2007. So the IRS says that the law actually changed in 2007 to make community property RDPs equal to spouses in 2007.
Right. So what they were saying is that the fact that California state income tax law said that you should report 100% of your wages on your own income tax return, that should be also controlling for federal tax purposes.
And that's a pretty unique position. Yeah. I mean, the IRS never relies. They rely on state property law, not on state tax law. I mean, the state of Washington has no state income tax, but you certainly pay federal taxes in the state of Washington. So state income tax law should not have any bearing on federal income tax. State property law should.
Yeah, you wouldn't think so. Okay, well anyway, so do you agree with that 2007 start date?
Well, you can tell from what I just said. The lawyer in me, especially the property lawyer in me, says that so long as it was truly community property, before 2007. That's the rule that should apply. Whether it was tax, I mean, the Congress could pass a rule tomorrow that said community property income of a husband, a wife, or a registered domestic partner should be taxed to the earner. That's perfectly possible. But until they do pass such a law, the Supreme Court opinion in Poe versus Seaborn ought to apply to all community earnings, whether they're from property or from personal services.
Okay. All right. Now, do you think that this new rule just applies to California RDPs? Because that's, of course, what they say that they're talking about.
Well, that's the private letter ruling was a request by California registered domestic partners, and technically a private letter ruling only applies to the taxpayers who requested the ruling.
Right.
So no one else is supposed to rely on it. But similarly with the CCA, that's the Chief Counsel Advisory, it cannot be cited as authority. But it's all we have in terms of the law. And so it's not, and it does only apply to California RDPs. And I've talked to people at the IRS. I've talked to people in Chief Counsel's office who worked on both the CCA and the ruling. And they agree that the reasoning in the ruling, which relies on Poe versus Seaborn, that's really the authority, should apply to any two people, registered domestic partners, spouses, in community property states if they are subjected to the community property regime. That would include the state of Washington. They have registered domestic partners. They have a community property regime. And it should also include Nevada. It has a registered domestic partner scheme, and they're also a community property state.
Does Texas have one?
Texas is community property. Louisiana is a community property state. But they have no recognition of same-sex couples. In fact, they have provisions in their constitution that say they will not recognize marriages or relationships between same-sex couples. So they are not subject to Texas community property law, and as a result, the ruling should not apply to them. Even if they were legally married in California, which they could be. You could be married in California, but once you move to Texas, you're not subject to the Texas community property regime.
Okay. Now, related to this, one of the issues, and actually what the IRS was talking about initially, as I recall, when they were talking about this community property regime and why it should be disallowed, was they were also citing the Defense of Marriage Act.
Well, the IRS did not. Now, a lot of people interpreted the original CCA as being based on the Defense of Marriage Act. The Defense of Marriage Act, as you know, it's a federal statute, and it says for purposes of federal law, that is the Internal Revenue Code, the regulations under the Internal Revenue Code, anytime the word spouse or marriage is mentioned, it will not include a same-sex spouse or a same-sex marriage. But the original CCA simply said Poe versus Seaborn has never been applied to anyone but spouses, and so it should not apply to anyone but spouses. It wasn't because of DOMA, it was because of their reasoning. So, in fact, the IRS has been clear, DOMA is not an issue for the community property question.
Okay.
Well, I should also mention, since we're having this interview, just a few days after a very significant court victory for the gay and lesbian community in the state of Massachusetts. A group of plaintiffs challenged the Federal Defense of Marriage Act under the Fifth Amendment, a violation of equality under the Due Process Clause of the Fifth Amendment, claiming that it was not justified. It was not rational. It didn't satisfy the rational basis test. And the district court ruled they were correct. And the court suit involves 4 couples who had tax claims. These are people who filed originally as single, because that's what DOMA required them to do. Then they amended their return and filed as married, filing jointly. The IRS sat on those returns for 6 months. After that time, they had standing to go into district court and challenge. They challenged, and the court ruled in their favor. So it struck down the Defense of Marriage Act as being unconstitutional, and that means that at least those 4 plaintiffs, those 4 couples, should be entitled to file jointly. Now, they have filed jointly. They should be entitled to their tax refund, because they get a tax refund by filing jointly. Not all of us would get a tax refund, but these 4 couples would. Now, that case is likely to be appealed,